Doing well. How are things over there?
We're just great.
All right. Well, we're about to get started.
Some things I just want to bring to your attention. We have a private attorney here for one of the domestic case, Yi Yang. So I don't know whether you want to do it after the move up or,
It just depends on how quickly we can do it.
okay.
I can pull it out while we're doing the Spanish interpreter. Any other changes, Miss Taylor?
Yes, it is some changes, Madam Clerk. Good
Okay.
morning, Denise.
Good morning.
How
Good
are
morning,
you?
Miss Taylor.
Good morning.
Good morning, court people.
Okay, you can give me all the changes. And
Court people, like air conditioning people or yard people.
The state, the
But today we got
PD,
court people.
all court personnel.
So wait a minute. You by saying that you made me think of something. And it is that I need for my lawyers to announce your presence for the record. Well,
Kafi Kennedy Swanson on behalf of the Office of State Attorney.
Tisha Fowler with the Office of Public Defender.
all right. You may continue with where you were with the changes.
Yes, ma'am. I add on to the move up, Denise, is Carter, Kiana Carter. She's a felony VOP. She would be the last move up.
Okay. Okay, that's it.
Yes.
Okay, gotcha. Pull that one out. We're gonna go to contact again over here. Okay. Is it?
Madam Clerk.
Good morning, Your Honor. This is Flavia Rodriguez, a certified court interpreter, previously sworn in today.
Did you say you have been or have not been?
Yes, Your Honor, I have been.
All right. Good morning, Ms. Rodriguez. Listen, I have a couple of cases for you. The first one is 2020 CF 6302, letter A, letter O. The second one is 2020 CF 6334 AO. Before we get started, was there any other information that the BRC people wanted to share with me?
I was just, are we gonna Spanish and then the move ups or,
Yes, ma'am.
and then the attorney?
Yes, have we pulled the attorney out?
Whenever.
Yes, ma'am. Are we wiping that thing off before we put that on him?
It's already been wiped down, Your Honor.
All right.
Sorry,
And
Your
are we
Honor.
gonna-
Is the defendant located in courtroom 2?
Yes, ma'am.
Thank you.
All right. Good morning, sir.
Good morning.
Can you tell me what your name is?
Jesús M. Silva.
Jesus M. Silva.
All right. Mr. Jesus Silva, sir, the court has reviewed your paperwork. I find probable cause for the charge of robbery, armed robbery with a deadly weapon. Court will set bond in this case at $7,500.
Your Honor,
Thank you.
the next person on the docket, Silva, Jesus.
Before we move on,
Sir, I also am appointing the public defender to represent you. Madam State,
Your Honor, we'd also ask for no contact, possession of no weapons.
granted. Court will further order no contact with the victim, that you possess no firearms or weapons as a condition of release. If you have any firearms or weapons in your possession, you need to surrender them to law enforcement within 24 hours of your release. Anita Laza Ortiz.
She bonded, Your Honor.
All right, previously bonded. All right, so that's the only other Spanish case I have. Is that correct?
Any victims that may need
All right. Do we have any victims that require the services of the Spanish interpreter this morning?
No, Your Honor.
All right. Ms. Rodriguez, I think we're good with you. So thank you for your assistance this morning.
You're very welcome, Your Honor. Have a very good day.
You do the same. Can I press N to get her off the
She's gonna
phone?
hang up.
All right. Darren Ellis,
Yes, ma'am.
the court finds probable cause for the offense of lewd or lascivious battery, count 1, and lewd or lascivious conduct, count 2. Bond will remain set at no bond on both counts. I'm appointing a public defender to represent you in this case. Thank you, sir.
Just for no contact, Your Honor.
Further, the court is ordering no contact with the victim or the victim's family in this case.
Thank you, Your Honor.
My man, I ain't, they just, yeah. This lady just put this on the paperwork. I mean,
Are you?
Jean Park. Mr. Park, the court finds probable cause, multiple offenses, trespass after warning. The court will order ROR as to the trespass. Battery. The court will order a $500 bond, order no contact whatsoever with the victim, that you possess no firearms or weapons and surrender any firearms or weapons to law enforcement within 24 hours of your release. The court orders bond at $1,000 as to resisting an officer with violence and $100 as to resisting an officer without violence. And as to felony battery, the court finds probable cause and bond is set at $2,500. As to your prior case,
State there's no objection and no action, Your Honor.
the court will take no action. And sir, the court is appointing the public defender in your case. Nicole Adams.
Yes.
Ma'am, the court does find probable cause for battery,
Yes.
domestic violence, and will order
Yes.
bond or PTR, $500 or PTR. Order that you have no contact whatsoever with the victim.
Your Honor, the victim is here.
I'll hear from the victim regarding contact.
State inquiry, Your Honor.
Yes, ma'am.
She's sworn in. Sworn in.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I swear.
Thank you. Can you state your name for the record?
Christian Lopez?
Mr. Lopez, are you afraid of Miss Adams?
No, not at all.
Would you like contact with
Otherwise.
her while this? Would you like contact with her while this case is pending?
Yes, ma'am.
If something happened in the future, would you feel comfortable in calling the police or 911?
Honestly, I would like to speak. If you let me at least 3
Sir, I
minutes.
just need you to answer the questions that the prosecutor asks of you. This is Judge Allen speaking. We need you to just answer her questions at this time, please.
Okay.
If something happened in the future, would you feel comfortable in calling the police or 911?
Yes, ma'am.
No further questions, Your Honor.
Anything from the defense?
No questions, Your
All
Honor.
right. With regard to your charge, Ms. Adams, the court will order no hostile contact with the victim in this case, which means you can have contact with him, but nothing hostile should occur between the two of you. I am ordering that you possess no firearms or weapons, ma'am, and I am ordering that you surrender any firearms or weapons to law enforcement within 24 hours of your release. Thank you, ma'am.
May I speak?
No, sir. Shayla Gold.
Yes, ma'am.
Ms. Gold, as to count 1 battery domestic violence, the court finds probable cause and orders bond of $500 or PTR. Further, the court will order a bond of $150 as to criminal mischief count 2. As to count one, the court is ordering that you have no contact whatsoever with the victim, that you possess no firearms or weapons as a condition of release, and that you surrender any firearms or weapons to law enforcement within 24 hours of release. I will allow you a one-time visit to the residence to pick up any personal effects in the presence of law enforcement, and the public defender is appointed in your case. Thank you, ma'am.
Your Honor, is that bond or PTR on count 2 as well?
No, sorry.
Just
As
count
to
one?
count two is just yes, only count one, ma'am.
Okay, thank you.
Sorry. Wait a minute. Sorry. Backing up to Ms. Gold's case. Yes, as to count two, it is bond or PTR.
Thank you, Your Honor.
Okay. She threw me off. Georgina Sharice Reyes.
Yes.
Ms. Reyes, the court finds probable cause for battery domestic violence in your case. The court will order a $500 bond or PTR. The court will further order that you have no contact whatsoever with the victim in this case.
Your Honor, it is a victim present.
The court will hear from the victim regarding contact.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give shall be the truth, the whole truth, so help you God?
Yes.
Can you state your name for the record, please?
Christopher Garcia Burgos.
Mr. Garcia, may I inquire, Your Honor?
You may.
Mr. Garcia Burgos, how do you know Ms. Reyes?
This is my girlfriend.
Are you afraid of her?
No.
Would you like her to be allowed to have contact with you while this case is pending?
Yes.
If something happened in the future, would you feel comfortable in calling the police or 911?
Yes.
No further questions, Your Honor.
All right.
Your Honor, I'm sorry. This
Yes.
is Officer Davis with Pretrial Services. Ms. Reyes is currently has an open case for VOP DUI. So she currently wouldn't be able to qualify for pretrial services.
All right, thank you for that confirmation. The court will order a $500 bond, order that you have no hostile contact with the victim. You can have contact, just nothing involving hostility. As a condition of release, the court is ordering that you possess no firearms or weapons, and if you have any in your possession, you must surrender them to law enforcement within 24 hours of your release. Thank you, ma'am. The public defender is appointed in your case.
Your Honor, are you going to take action on the open case?
Oh, no, ma'am, no action.
Okay, thank you.
All right, Christopher Burrow.
Yes, ma'am.
Mr. Burrow, the court finds probable cause for the offense of armed robbery with a weapon. Bond remains set at $5,000. As to the petty theft and the carrying concealed weapon and possession of paraphernalia, prior cases that you have, does the state have any input?
We would ask for those bonds to be revoked, Your Honor.
The court will revoke bond on both cases, 2020 CF 6315AO and 2020 CF 6315. Are they the same?
4104 is the hearing concealed. 2012 CF 4104.
Okay, sorry. 2020 CF 4104, 2020 MM 3470. Bond is hereby revoked, set it, ROR is revoked, set it, no bond. All right, thank you, sir. Sir, the public defender is appointed to represent you. Terrence Givens. Mr. Givens, the court's reviewed your file, and I do find probable cause for sexual battery on a person less than 18 years of age. Bond is set at no bond, as well as false imprisonment. Bond will remain set at $3,000. As to that count, the court is ordering that you have no contact with the victim in this case or the victim's family members, that you possess no firearms or weapons, and surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release. The public defender is appointed to represent you in your case, sir. Thank you.
One must state it now.
They didn't know. Thank you, sir.
All right.
Adrian Jordan.
Yes.
Mr. Jordan, the court does find probable cause for burglary of an occupied conveyance. Bond remains set at 1,000 as to that count. Possession of cocaine, count 2, bond remains set at 150, and possession of paraphernalia, bond remains set at $100 on that count. Oh, yes, sorry, sir. Yes, the court will leave it at 1,000. Sir, further, the court is ordering that the public defender is appointed to represent you in your case. Thank you. Joshua De Leon. Joshua De Leon.
He's coming right up, Your Honor.
There's no one there, just so you all know. I know you guys will have to kind of walk around to see the monitor, but what's going on with Joshua De Leon?
They trying to locate him, Your Honor.
Okay, let's pass Joshua De Leon.
He's coming right
And-
now, Your Honor.
He's coming right now? All right.
Right now.
All right.
All right.
Sir, are you Joshua De Leon?
Yes, ma'am.
Mr. De Leon, the court finds probable cause for count 1, providing a false ID to law enforcement. Bond remains set at $500. As to count 2, the court finds probable cause for resisting an officer without violence. Bond is decreased to $150 on count 2. I am appointing the public defender to represent you in your case. Thank you, sir.
All right.
Timothy Lafferty. Lafferty,
He's mental health, Your Honor.
mental health.
I think the public defender's also will waive his appearance, Your Honor.
All right. As to Mr. Lafferty, his appearance has been waived and PD has previously been appointed. He did have this second case here, and I assume the state is not recommending any action on that. Okay, thank you. Yes, ma'am. Bond is stayed on all counts. Kayla Likens. Is that who you are, ma'am? Is that your name? Hello? Are you Kayla Likens? All right, we'll pass this case. We'll reschedule it for tomorrow. All right. Defendant was standing there but refused to answer, so I don't know who she is. All right. Terrell Thaddeus.
Yes, ma'am.
Mr. Thaddeus. The court does find probable cause for the offensive trespass on property after warning. You have a similar prior case. What says the state? The state.
Adjudication, credit for time served, no return.
Okay. On both cases?
On
Or the prior
714 case,
3714.
that's the one I have.
That's this case.
Yes, Your Honor. Let me
So-
give you 1 second and pull up the other case.
The other case is, I don't have a case number.
I have a 2020 MM 1461.
1461. Oh, I do have it. I just didn't understand my clerk's handwriting. It's very beautiful handwriting, and I sometimes can't see beautiful handwriting. So it's beautiful though. It's nice and artistic. So with that case, and no recommendation to take action on that?
I'm seeing if I can resolve it real quick, Your Honor.
Oh, I see. Okay.
1 second. I'll do the same adjudication credit for time served as well and no return on the 2020 MM 1461 case. I just want to make sure there's no cost of investigation, Your Honor.
All right, Mr. Thaddeus, the recommendation on your two cases, both cases, is an adjudication of guilt credit for the time that you've already served in the Orange County Jail in order that you not return to the location where these trespasses occurred. Sir, if you're willing and you want to, you can accept those recommendations at this time. I'll sentence you at this time. There are mandatory court costs that are also involved in these type cases, and I will order the court costs to be paid through the clerk's collections program. Or, sir, you can delay in making a determination that you want to accept this and have time to talk to the public defender that's been appointed to represent you in your case.
No, I'll take time, sir.
All right, sir. Sir, do you understand that you have been made an offer in these two cases? Answer my question.
Yes, I understand.
And do you understand that no one can force you or threaten you to take those recommendations? You understand that?
Yeah, I hear you. Yes, ma'am.
Are you under the influence of any alcohol or drugs or medication that would affect your thinking at this time?
Oh, ma'am.
Do you understand that a conviction on your cases would subject you to deportation if you are not a United States citizen?
I understand.
All right. There's a sufficient factual basis. You are alert. You're intelligent. I'll adjudicate you guilty, order credit for the time that you have already served, and I will further order court costs on both cases. The court costs are payable through the clerk's office. The court will order minimum payments to the clerk's office of $10 per month, first payment being due no later than 90 days from your release from incarceration. You do have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Sir, do you have any questions about what just occurred in your case?
No, sir. No, ma'am.
All right, thank you, sir. Betsy Carr. Ms. Carr, is that who you are?
Yes, ma'am.
All right. Ma'am, the court's reviewed your file. The court does find probable cause for resisting an officer without violence, and bond will remain set at $500. As to count 2, the court finds probable cause. Just one moment, ma'am, and then I'll hear you. Providing false ID to a law enforcement officer, and bond will remain set at $100 on count 2. Now, what were you going to say, ma'am?
Ma'am, if you look into your records, if you look back in Hall to Detroit, Michigan, I told that officer, and I told them when I came in, my name is Bessie Renee Johnson, and I gave them the correct, my ID was stolen. And my mother has been passed away.
Ma'am, let me just interject right now that what you are providing is helpful information for your case, but you're providing it in the wrong forum and to the wrong
I'm
person.
back up from behind me, but like I said, what the officer did was he did he asked me, can I please finish?
If you want, you can tell all of that information to the public defender that is assigned to represent you in your case. Because
where is he at?
Hold on a moment, and it's a she. She's sitting right here in the courtroom. She's sitting right here in the courtroom.
That's not her right now?
Yeah, no, she's taking notes, writing down the information that you're providing. But I think that you probably want to give more detailed information to the public defender at the appropriate time. Now is not the time to
This is the time, ma'am. This is the time. Because like I said, I'm telling the truth. My name is Bessie Renee Johnson. I was never adopted or nothing.
From the microphone. Let her step back just for a minute from the microphone so I can finish. All right. So just finishing here, ma'am, the court is staying the bond of $500 on count 1 and $100 on count 2. The court is appointing the public defender, and you can continue to provide the information that you started to provide to your public defender. Thank you. She's excused.
Your Honor, she has 3 counts for that case. It's the
no, I don't see 3 counts.
yeah. Count 1 is resisting without violence. Count 2, providing false ID. Count 3, providing false ID.
Well, I don't see a count 3.
The officers, what they do sometimes is right next to the count, they put 2.
Oh.
And she currently has an open case. She's out on RR.
Can you provide a case number? The clerk didn't receive that information.
It's 2020 MM 003 071 AO.
Thank you.
So the court does find probable cause for the second count of providing false ID. For that count, bond is set at $100.
You make that call back to Detroit, Michigan, like that cop did. In order for him to find
What's that,
out my
you have the
own-
misdemeanor case?
First, tip was he did not even recognize who I was. So
All right.
that's actually
The court will-
a lawyer to represent me right now, or can we
The court
say
will,
right? That's is the correct thing to do because my name is.
Hey, I do have the paperwork on that 2020 MM 3071.
Is her name different?
The name is Betsy Carr. And I'm not sure if there ever was a bond. It has NA, not applicable. Does the state wish for me to take any action on this or refrain from
There are mental health issues, so no.
No action will be taken as to that.
Y'all don't know what y'all doing at all, period. At all. So the question is, what's your name? What's that judge name up there? And I want my papers too, in my hand. And what's your name, bitch? Because whatever false information you got against D yourself, you need to remove yourself from there.
Thank you so much, Ms. Carr. You're excused now.
Johnson, I need my papers too.
We'll make sure you get them.
I don't trust you either.
Kayana Lachey Carter.
Yes, ma'am. Okay, I need the papers right now. Like I said.
Ms. Carter.
Yes, ma'am.
The court, you were picked up on a warrant for violation of probation. Bond remains set at no bond. As to that count, ma'am, you have to go before the judge on that case. You also have, she has a private attorney on this, on the VOP?
On the deal.
Okay, sorry. So ma'am, you've already retained legal counsel as to that case. You also have is this her case or Ricky Williams' case?
It's her case.
All right, you have a child support case. You were picked up on a writ for that, so I'm informing you at this time that you will be released as to this case only. And make sure that you make your next court date on July 6th.
Yes, ma'am.
As to the writ. Okay, thank you, ma'am.
Okay.
Oh, poor thing.
The next is the private attorney, Your Honor.
Good morning, Judge.
Is that this one?
The last one, Judge, it should be Lee Yang.
And they also have a victim, present too.
As to Yi Lang, Lee, okay. Mr.
Judge John Notary for the record.
Okay, Mr. Notary, your client
He stands
was charged with battery domestic violence. The court does find probable cause for that offense. I understand a victim is present.
She is, Judge.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give shall be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record, please.
Stephanie Murray.
Thank you.
A state inquiry, Your Honor.
You may.
How do you know Mr. Yang?
We've been dating since October 2018.
Are you afraid of Mr. Yang?
Yes.
No further questions, Your Honor.
All right.
Judge-
Mr. Notary, did you have any
I
questions?
do, thank you, Judge. Ma'am, the location where this occurred, 9728, the allegations occurred 9728 Wild Oak Drive, Windermere, Florida. Who owns that home?
Objection, relevancy.
Overruled.
We couldn't hear the state.
Mr. Yang does.
Okay. The two of you are not married?
No, I've been living there since January.
Okay. and it-
We're engaged.
Since January. But you have an address at 321 Emerald Circle in Ocoee, apartment 321?
My mother has been living there.
But you reside there also, right?
No, I've been residing with Mr. Yang since January.
All right, but there's rooms there for you, correct?
He just moved my mother into a one-bedroom in the same apartment, and I can no longer stay in there.
Oh, well, this other residence is, the 321 is a 3-bedroom, correct?
All right,
is-
Mr.
that's
Notari, we can
correct.
move on from this line of questioning. You got anything else?
Yes, Judge, I'd ask the, Lee Yang to testify, please, Judge.
Is there any specific question?
Have you been sworn in?
You swear me?
Okay.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do, yes.
Okay,
Thank
sir,
you.
where do you reside?
9728 Wild Oak Drive, Windermere, Florida.
Okay, and what do you do for a living?
I'm a radiologist.
All right, and where are you a radiologist at?
I'm a radiologist for Advent Health. I primarily work from home these days.
Okay, why is it that you work from home?
Specifically because of the coronavirus, the hospital wants their staff to be healthy and be able to work without getting sick and being out of work.
Okay, and you own the home at 9728 Wild Oak Drive?
Yes.
You are not married to the alleged victim in this matter?
No.
Does she have any possessory interest at all in this property?
No.
Okay. Sir, why is it that you need to return to the home for work purposes?
Specifically to be able to access the workstation that is in my home. It's a workstation that has four medical monitors, requires high-speed internet and a VPN, a virtual privacy network, to be able to work. And I'm supposed to be working this weekend, and I have to find a place to work, essentially.
All right, does the hospital not want you to come in because of the virus? They prefer that you work at home?
Correct.
Okay. And are patients' records and documents and services essential to patients at risk if you do not return to the home?
Correct. Yes.
That's true? Okay.
Your Honor, I'm sorry, he's lying. He's been going into the hospital every day.
Thank you, ma'am. Let me just allow Mr. Notari to complete his questioning. Mr. Notari, are you almost done?
I am, Judge. Sir, there is another apartment that Stephanie Murray could live at, correct?
I know her mother is moving into another apartment.
Okay, her address is not the 9728, is it?
No.
Okay, it's not on
Sorry,
the
he's lying. I've been there since January. Why are you doing this? I'm homeless.
We'll ask the victim to not say anything. State will inquire the victim once Mr. Yang is finished.
All right, ma'am, if you'll just hold on just one moment. I think the state intends to ask you some additional questions, and you'll have an opportunity to respond to the things that are being presented at this time by the defendant. If you'll just hold on one moment. Mr. Notari, would you just go ahead and complete your
Yeah, Judge,
questions?
that's fine for now, Judge. I'll let the state inquire and then I'll.
All right,
present our-
and the state may inquire. He asked questions. I don't know if you want to.
I have a couple questions, Mr. Yang.
Go ahead.
Mr. Yang, your 4 monitors and your computer, is that nailed down to the foundation of your home?
No.
No further questions.
Right. And I actually do have a question. Is this a rental property, sir, or is this a property that you have a mortgage on?
A mortgage.
And how long has that mortgage been in effect?
Since 2013, I believe.
Thank
bought
you,
the house
sir.
in 2011.
All right. Thank you, sir. Ms. Kennedy Swanson, did you want to ask any additional questions to the victim?
Yes, Your Honor. I just have a couple of redirect questions. Okay. And Ms. Murray, you've been living at the home since January of this year?
Yes, ma'am.
You have personal property at that home?
All of my property.
No further questions, Your Honor.
Okay.
Argument.
With regard to bond, the court has made a decision to set bond at $500. With regard to, and the court is also ordering no contact whatsoever. With regard to possession of the property, I'll hear from both Mr. Natari and Ms. Kennedy Swanson.
Your Honor, state would request PTR in addition to bond. This way, if there's something happens, the victim has somebody to reach out to quicker than reaching out to the state attorney's office. So we'd ask for bond and PTR. Your Honor, the state does not believe the court has jurisdiction to order Ms. Murray out of the home at this stage. I believe that the court only has jurisdiction over Mr. Yang, as that's who's in front of the court. The state has no objection to a one-time return with law enforcement to retrieve any of his belongings that he may need for a temporary basis. If Mr. Yang would like to start eviction proceedings on Ms. Murray or anything like that to get her out the home, he is welcome to do that. We don't believe that's in front of the court today. Only thing we believe that's in front of the court today is his conditions of release and no contact with the victim. We will require one-time return with law enforcement to maintain separate residences, no weapons, no firearms. There are other avenues that are in that Mr. Yang can use in order to remove Ms. Murray from the home that is not for the court today.
Mr. Natari?
Thank you, Judge. Judge, I don't see that PTR is needed. Mr. Yang, you can check with the state, to my knowledge, has absolutely no criminal history. Judge, it would possibly hamper his duties as a physician and a radiologist at the hospital if he had to come back down in here and check in. If the court orders that he not be returned home, he will indeed begin eviction proceedings. However, Judge, the one-time return may not be enough, and patients' health records and during this difficult time might be at risk if he is not allowed. It's a giant setup, as my understanding, to get all of his equipment out of there to wherever he's going to be going now until he can return to the home.
All right, I'm ready to enter my order. At this time, the court orders as follows. The defendant must possess no firearms or weapons as a condition of release, and the defendant must surrender any firearms or weapons to law enforcement within 24 hours of release. Also, within 24 hours of release, the defendant may enter the residence. The victim should not be there. The defendant must notify the victim of his release through you, Mr. Natari. Through you. The attorney must notify the victim of the defendant's release.
She's not responding to my phone calls, Judge.
All you have to do is make an outreach. If she refuses to not be there, then that's on her. I'm giving him the authority to retrieve as much of his work-related equipment as possible within that first 24 hours. If he cannot get it all out of there, then I can extend it, and I will extend it to 48 hours.
Thank you, Judge.
However, you must appear with him, Mr. Natari, or ensure that law enforcement appears with him. Since I'm giving him the authority to do it so quickly, I don't know if law enforcement is going to be available to go with him that quickly.
Yeah, and I'll be out of town tomorrow, Judge. I'm sorry.
Okay.
Well, there's another. We got another lawyer to go.
It's the concern I have. I want Ms. Murray to remain on the property, but I want him to be able to pick up the medical related equipment.
I got you.
And particularly patient records. And I don't know how, as Ms. Kennedy Swanson has indicated, I don't know that I can order Ms. Murray to not touch those things. I don't want to get involved in ordering her to do things that may be outside of the ability of this court to make rulings. But I want her to be able to remain on that property. So, Ms. Murray, I want you to stay on the property, but I want him to be able to enter the property to get his medical related equipment. And so you will be allowed to remain on the property, and if he wants to evict you, he can do that. But he is allowed to retrieve very important and it sounds like somewhat sensitive records.
I'm sorry, Your Honor, if I can say there's no medical records in the house. There's only monitors and a computer which he connects to the hospital servers on.
Well, ma'am, computers have records on them, so you don't know that. So I want him to be able to get those items, because you never want to be accused yourself, ma'am, of interfering with patient data. So this is for your protection as well as for the protection of the patients that he has under his control. So if Mr. Natari cannot attend with you, Mr. Yang, you have to wait until you can get law enforcement. I want you to be able to get those records as quickly as possible, but I cannot allow you to go there alone. You have to either, Mr. Natari has to go with you that first time, or law enforcement.
I've
If you
explained
cannot,
that to him, Judge, yeah.
yeah, and if you cannot obtain law enforcement within 48 hours, then you have to wait until you can get law enforcement to go with you. And that's for your protection as well as for Ms. Murray's protection. And Ms. Murray, you will retain the right to reside in the property. And I hope that helps you, because you said you might be homeless, but that will help you so you will retain that right. Do you understand, ma'am?
Yes, ma'am.
And do you understand, Mr. Yang? I know it's kind of complicated, but do you understand?
Yes.
Okay. All right. I gave those time frames only because of medical records. The time frames, you are not restricted. If you can't get there within 24 or 48 hours, that's okay. Get there when you can get there with law enforcement. Okay?
Okay.
All right. I think I've covered everything. Did I miss anything, Ms. Kennedy Swansea?
No, Your Honor.
All right.
Judge,
Mr. Natari?
Just so we understand, there's a $500 bond and that
Yes,
should-
sir.
Okay, thank you, Judge.
No. $500 bond.
Thank you very much, Judge.
Thank you. Why am I doing it?
We have law enforcement present, Your Honor.
Okay. Corrections, jail people, corrections people. We're moving up defendant Jessica Haney, Haney. Let me know as soon as Jessica Haney is moved up. All right. Is this out of order or in order?
It's in order.
Okay. Samuel Bellamy, is that who you are, sir?
Yes, ma'am. Good morning, Your Honor.
All right. Good morning. All right, sir. So you were picked up on a writ for child support violation. At this time, I'm going to order your release as to this case only and schedule your case for a hearing regarding your child support situation, okay? Yes, sir.
Your Honor, I have my receipts that I paid $31,000 on my home, when I sold my home. The system wasn't updated. I have a full-time job. I have my receipts here because I ride around in my car with them. I was in a car accident.
Well, what I want you to do is make a copy and bring those receipts with you to the hearing, okay?
Ma'am, could you tell me when that'll be?
July 6th.
So how much do I have to pay to get out?
I'm releasing you.
Oh, praise God. Thank you, Jesus.
Judge, were you releasing him to all 3 cases he was in on?
Was he in on 3 cases?
Yeah, there was 3
I also have a
DR cases.
from child support saying I am current in child support.
All right. So this is another child support, and this is another child support. Yes, ma'am. Releasing him as to all 3 cases, and your court date is the same on all 3 cases, sir.
Yes, ma'am. Thank you very much, Your Honor.
That's Jessica, Your Honor.
I need that one back. Oh, you got it. Y'all keep me straight. Yeah. Oops, sorry. All right, ma'am. Is this Miss Haney?
Yes, ma'am.
All right, Miss Haney. You were picked up on an out-of-county warrant, Miss Haney, Jessica Haney,
Yes, ma'am.
from Polk County. Bond was set at $5,000 and will remain set at that amount. You also have another out-of-county. Actually, it's a duplicate. It's the same thing. All right, ma'am. Our staff will contact Polk County and let them know that you've been picked up on this case. All right?
All right.
I believe there's law enforcement that wanted to be heard from Polk County.
Oh, you from Polk County?
From Polk County, Your Honor.
All right. And is there anything that you'd like to add, sir, at this time? Okay, let's swear him in.
You solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God.
Now, so I need you to come close to the microphone. Yeah, here's fine. I think that one's on. Go ahead.
The reason why I'm appearing in your court today is
We can't hear him, Your Honor.
Okay. Yeah, try to, yeah, there you go.
we would like to seek to have Miss Haney's bond either increased or no bonded because of a couple extenuating circumstances with the case. Miss Haney is currently on probation for the same charge since 2017, where she called in a bomb threat to the Lakeland Police Department. I spoke to her probation officer, state probation officer Cantu, this morning, and she's currently seeking, as of today, a VOP warrant for her. And also there was a case recently as well on April 14th where Ms. Haney called in a bomb threat to the Orange County Sheriff's Office Telecommunications Center. So this is a repetitive course of conduct with Ms. Haney.
All right. Thank you very much for that input, sir. What agency are you with again?
With Polk County Sheriff.
Sheriff's Office. All right. Ma'am, if you cannot hear, the deputy with the Polk County Sheriff's Office has asked for an increase from the $5,000 and or for the court to issue a no bond warrant. And I'm going to grant that request at this time. I'm going to order no bond. Now, the judge in Polk County still will be contacted, ma'am, and this still could change for you. But pending contact with Polk County, your bond is set at no bond.
Yes,
Thank you, ma'am.
Thank you.
Thank you, Your Honor.
All right. Reginald Noel.
Yes, ma'am.
Mr. Noel, you were picked up for a VOP, violation of probation warrant. Bond will remain set at no bond on your violation of probation. I have appointed the public defender to represent you. Thank you. Carl Andrews.
Yeah.
Mr. Andrews, the court has found probable cause for your charge of aggravated assault with a deadly weapon. The court will order a bond in this case at $1,000. Further, the court will order that you have no contact whatsoever with the victim in this case, and the court is ordering that you not return to the location where this incident occurred. Further, sir, the court is ordering that you not possess any firearms or weapons and surrender any weapons or firearms to law enforcement within 24 hours of your release.
Your Honor, will the court consider PTR?
Yes, the court would consider PTR, and I will order PTR in your case, and rather than a bond, I'll order PTR.
So where I have to go and stay? Where would I?
I could not understand what you said. Can you repeat your question for me?
Where would I go and stay if I can't go back to the premises?
Where will you go for what?
To stay. You see, I can't go back to the premises. The house belongs to me. My stepson is there,
and he come there and he stand there and he walk in there and
See the file again.
want
Does
to
the
put me
stepson
over,
live at
walk
that
over
residence?
me. Must step, must.
I have no objection to separate residences, and if the stepson is no longer residing there, he can reside there. However, if the stepson is still there, he cannot reside.
All right,
But
sir,
yeah,
the address where this occurred at is 600 Madison Avenue. Is that where the victim lives right now?
he's just come there to stay there. He's not living there. I live in there. I own the house. Me and my wife. He
Do you
asked.
know where the victim is residing at right now?
I don't know. When I left, when they locked me up, they all get together and say they go take all the furniture out of the house and leave the house rented. They moving
Sir,
them.
I'll order as follows. You are ordered to have no contact whatsoever with the victim.
Well,
You must
so what?
Listen, sir, listen to me. You must maintain separate residences, which means that upon your release, if the victim is not at your home and is residing somewhere else, that's fine. You can go back into your residence. However, since you don't know for sure where he is, you must contact law enforcement and appear in the presence of law enforcement to make the determination that he's no longer there. All right, sir? And if he's still there, then you'll have to talk with your lawyer, your public defender, and they can file a motion if they feel like it's necessary to do so, or you can pursue other means of removing your stepson from the house. Thank you. Jermaine Barnes.
Yes, ma'am.
Mr. Barnes, the court does find probable cause for aggravated battery in your case. Bond will remain set at no bond in this case. The court is ordering no contact with the victim in this case. And
Mr. Barnes, Your Honor?
yes, and Mr. Barnes, I have appointed a public defender to represent you.
Your Honor, what was the bond?
I believe he's entitled to a bond, Your Honor.
The bond will be set at $5,000. The court's ordering no contact whatsoever with the victim.
So Your Honor, you said bond set at 5,000?
5,000.
Okay.
No contact whatsoever with the victim, possess no firearms or weapons, and surrender any firearms or weapons to law enforcement within 24 hours of your release. Thank you, sir.
Thank you, ma'am.
Derek Rogers.
Yes, ma'am.
Mr. Rogers, the court finds probable cause for your charge of aggravated stalking after an injunction. The court sets bond in your case at $1,500, orders no contact with the victim whatsoever, no return to the location where this incident occurred. The court orders that you possess no firearms or weapons and surrender any firearms or weapons to law enforcement within 24 hours of your release. Thank you, sir.
Yes, ma'am.
Okay, Luis Manuel Ortiz.
Yeah, Dennis.
Is that who you are?
Yes.
Sir, the court does find probable cause for the battery, domestic violence, and orders bond of $500. Further, the court orders no contact whatsoever with the victim. The court orders that you possess no firearms or weapons as a condition of release and surrender any firearms or weapons to law enforcement within 24 hours of release. Further, the court is ordering a revocation of the bond in case number 2019 CF 15364AO unless the state would prefer for me not to.
No, Your Honor, request to be revoked.
That bond is revoked and set at no bond.
Your Honor, which charge are you putting the $500 bond on?
I'm putting the $500 bond on the only count that I see, which is battery domestic violence. Did you think there were multiple counts?
Yeah, he also has another case, a 2019 CF
That case was not provided to me. The only case I have is the 2020 MM240AA.
Oh, okay, thank you. Sorry about that, Your Honor.
Okay, thank you, ma'am. Walter Drake.
Yes, ma'am.
Sir, the court finds probable cause for the offense of battery, domestic violence, for which you were charged, and I will order a bond of $500. Sir,
Your Honor.
actually, sir, I will order PTR, release on PTR in your case. As a condition of release, I am ordering that you have no contact with the victim whatsoever.
Yes, ma'am.
That you not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to retrieve personal belongings. You must possess no firearms or weapons as a condition of release, and surrender any firearms or weapons to law enforcement within 24 hours of release. Thank you, sir.
All right, thank you.
Your Honor,
Yes, ma'am.
he does qualify for PTR.
Yes, the court orders PTR as to this gentleman. I guess I need to slow down a little bit. Stephanie Hernandez. Ms. Hernandez, the court finds probable cause for the offense of battery, domestic violence. The court will order your release on PTR. As a condition of release, pretrial release, as a condition of release, you must have no contact with the victim whatsoever, not return to the location where the incident occurred, with the exception of a one-time visit in the presence of law enforcement to retrieve personal belongings. You must possess no firearms or weapons as a condition of release, and surrender any firearms or weapons to law enforcement within 24 hours of release. Thank you, ma'am.
Thank you.
David Howard. And as to you,
Your Honor.
Mr. Howard, the court finds probable cause for the offense of battery, domestic violence, and I will hear from the victim in this case.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, I do.
Thank you. Can you state your name for the record?
Joshua Nozell.
You may.
Mr. Nozell, how do you know Mr. Howard?
That's my brother.
Are you afraid of him?
No, ma'am.
If something happened in the future, would you feel comfortable in calling the police or 911?
Mr. Roselle, did you hear the question?
What she said?
If something happens in the future, would you feel comfortable calling the police or 911?
If something happened in the future?
Yes, sir.
Yes. Yes, ma'am. Like, that's the right answer, right? Wrong answer?
Well, we can't give you
I don't
the
call the
answer.
police. I'm sorry, Judge. I don't call the police. It's just...
You have to answer how you feel is appropriate, okay?
He's not a threat. That's my brother. Like, I won't call the police. That's my brother. Like, what I don't need to call the police? We resign issues. My mother was just scared, so she called the police. Like, that's my brother.
All right. Well, don't you guys scare your mom like that anymore, all right?
Yes,
Let
ma'am.
me just enter a ruling based on the testimony that I have heard from you, unless you have anything else, Miss Kennedy Swanson, or you have anything, Miss Fowler.
No, Your Honor.
No, Your Honor.
All right, my ruling is as follows. I'll order a bond of $500, order that you have no hostile contact with the victim. You can have contact, just no hostile contact. That you possess no firearms or weapons as a condition of release, and surrender any firearms or weapons to law enforcement within 24 hours of release. And thank you both.
Thank you, ma'am. All right.
Stating that I understood that you said bond plus pretrial release on this defendant, but they're saying that you said bond or pretrial release. So I just need a clarification on the record.
I said bond or. Wasn't she like the first one? Bond or? I did. I said bond or. I remember that one because she was the first one. Okay. Era Inman,
Yes, ma'am.
you were charged with battery, domestic violence. Court does find probable cause for that offense, and bond will be set in your case, sir, at $500. Further, the court will order that you have no contact whatsoever with the victim.
Yes, ma'am.
The court is ordering that you not return to the location where this incident occurred, with the exception of a one-time visit in the presence of law enforcement to retrieve any personal belongings. You must surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release and not possess any firearms or weapons as a condition of release. Any questions?
No, ma'am.
Your Honor, he does qualify for pretrial release.
I just noticed that. The court will order pretrial release in his case.
Thank you much.
You're welcome.
That's it.
All right. Roberto Morgan.
Yes, ma'am.
He also has a victim here, Your Honor.
All right, thank you very much. The court finds probable cause for the offense of battery. You do qualify for pretrial release. I will order pretrial release. I will hear from the victim regarding contact.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Thank you. Can you state your name for the record?
Tommy
What's your last name?
Kingman.
You may.
Mr. Kingman, how do you know Mr. Morgan?
My dad?
Are you afraid of him?
Not at all.
Would you like for him to have contact with you while this case is pending?
Of course.
If something happened in the future, would you feel comfortable in calling the police or 911?
Yes.
No further questions, Your Honor.
Mr. Kingman, how old are you?
20.
Do you have any questions, Ms. Fowler?
No questions, Your Honor.
All right, the court will order pretrial release, order no hostile contact with the victim. Further, the court is ordering you possess no firearms or weapons and surrender any firearms or weapons to law enforcement within 24 hours of your release. Thank you. The court is appointing the public defender in your case as well. Thank you.
Yes, ma'am. Thank you.
Chance Hate.
Yes, ma'am.
Tay.
Pate.
All right. The court finds probable cause for battery, domestic violence, orders of a bond of $500, and no contact whatsoever with the victim.
victim is here, Your Honor.
All right, we'll hear from the victim regarding contact.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, ma'am.
Can you state your name for the record?
Chase Pope Pate.
Mr. Pope, may I inquire, Your Honor?
You may.
Mr. Pope Pate, how do you know Chance Pate?
That's my brother.
Are you afraid of him?
No.
Would you like for him to be allowed to have contact with you while this case is pending?
Sure. Yes.
If something happened in the future, would you feel comfortable in calling the police or 911?
Yes.
No further questions, Your Honor.
Thank you very much. The court will order no hostile contact with the victim. The court further orders that you possess no firearms or weapons as a condition of release and surrender any in your possession to law enforcement within 24 hours of your release. Thank you, sir.
Thank you.
Josiah Tyder. Is that who you are?
Yes, ma'am.
Okay, very good. The court finds probable cause for the offense of battery, domestic violence, and bond is set at $500 in your case. Further, the court is ordering no contact whatsoever with the victim, ordering that you possess no firearms or weapons and surrender firearms or weapons in your possession to law enforcement within 24 hours of release. I will authorize a one-time visit in the presence of law enforcement to retrieve any personal belongings. Thank you. And the public defender is appointed in your case. Miss Kennedy Swanson, what time we need to take that break? Is it 1 or 1:30?
1:30.
Oh, okay. Kimberly Atkins, that's not who you are.
No, ma'am. Keon
Oh,
Bell.
look. Miss Atkins bailed out? Is that what you said?
Wait, no.
You have an inmate number, Your Honor? She's not on our docket.
200-11964.
She bonded.
She bonded?
Thank you.
All right, Mr. Bell,
Yes, ma'am.
Keon Bell. The court finds probable cause as follows. Count 1, possession of tetrahydrocannabinol. Bond remains set at 1,000. Count 2, possession of MDMA ecstasy. Bond remains set at 1,000. Count 3, possession of cannabis with the intent to sell or deliver. Bond is set at 150. Count 4, possession of cannabis. Bond is set at 150. Count 5, carrying a concealed firearm. Bond remains set at 2,500. Count 6, possession of a firearm or ammo by a convicted felon. Bond is set at 150. Count 3, grand theft, third degree of a firearm. Bond is set at 150. Count 8, resisting an officer without violence. Bond is set at 100. And count 9, possession of drug paraphernalia. Bond is set at 100. You have another case. Oh, sorry. Did I miss something?
It might be on the.
Oh, ooh. Yeah, well, there is. Man. I don't remember any oxycodone.
Your Honor, state has no objection to a modification of the bonds to treat count 6,
Okay, let me go back. Count 6, ma'am.
Yes. To raise that bond to $5,000. 2 on count 1, 150. Count 2, 150. Count 3, 150. Count 4, 150. Count 5, 150. Said count 6, 5,000. Count 7, 150. Count 8, 100. Count 9, 100. And count 10, 150.
All right, and the court will enter that order on all with the exception of count 10 because I still need to review count 10. So, did you catch that or do I need to repeat it again? So let me repeat this, Mr. Bell.
Yes,
The
ma'am.
court finds probable cause for count 1 through 9. Bond is set at 150 on all counts, with the exception of count 6. Bond is set at 5,000. Count 7. Bond is at on 150. Sorry. Count 8. Bond is set at 100, and count 9. Bond is set at 100. All the other counts above are 150, and 7 is 150. But if you give me just a minute, let me just see if I can find the oxycodone on here. I don't know what oxycodone.
No objection to ROR as to count 10, Your Honor.
Court will ROR you, sir, as to count 10.
No objection to no action on the out on bond case.
And the court will take no action as to the out of bond case.
Thank you.
Public defender is appointed to represent you, sir. Ashley Eastwood.
No, ma'am.
He's mental health, Your Honor.
She's mental health.
She.
And Your Honor, we waive her appearance.
All right. The court did find probable cause. The public defenders waived their appearance. The court did find probable cause after reviewing this file, and bond remains stayed at $2,500. Jeffrey
Fernandez.
Fernandez.
Good morning, Your Honor.
Good morning.
How are you?
Fine.
All right.
The court finds probable cause for moving violation, driving on a license that was suspended. Bond is set in your case at $1,500. The court will take no action on the out of bond case that you previously were picked up on. Public defender is appointed in your case. Thank you, sir.
Ma'am, there's no way I'll be able to RR on that
because of financially, due to the coronavirus, my family is struggling very badly, and I need to help my mom. I was trying to get out there and get a ride situated so we can move our belongings into a storage, and we're basically homeless. So I just need help to help her. She's older. She's 7 years old. She's not in good health, and we don't have any money. And I was just released on the 15th, and everything was starting, to look up because I went and filled out an application at 2 landscaping places, and on Monday is when I'm supposed to go.
All right, sir, I'm going to have you stop talking right now.
Okay.
Let me tell you what I will do. I don't really know whether anything that you just said is true or not.
Yes, sir.
However, I will go ahead and reduce the bond a little more. I'm not going to give you ROR, but I'll reduce the bond from 1,500 to 700.
Okay.
Good luck, sir.
Thank you.
David Flores. David Flores.
Mental health, Your Honor.
All right.
Honor, we waive his appearance.
All right. The public defender has been appointed and waives his appearance. The court does find probable cause for both count 1 and count 2. Bond stays at $5,000 on count 1 and $250 on count 2. Roy Demir Gonzalez Delgado.
Yes, ma'am.
All right, the court finds probable cause for fraudulent use of personal identifying information. Bond remains set at $1,000. Count 2, unlawful possession of a stolen credit or debit card. Bond
Subsidiary 150, Your Honor.
bond is set at $150. Petty theft. Bond is set at $100. Obtaining goods with the credit card of another. Bond is set at $100. Public defender is appointed on your case. Thank you.
Thank you, ma'am.
Julian Thomas Howe.
Yes.
As to the charge of second-degree murder, the court does find probable cause. Bond remains set at 0, no bond. Public defender is appointed to represent you. Thank you, sir. Irvin. Owen Irvin.
Yes, ma'am.
Sir, the court does find probable cause for battery on a public transit employee. Johnson.
Yes, ma'am. Jamar Anthony Johnson.
Jamar Anthony Johnson. The court finds probable cause for leaving the scene of a crash with property damage. Bond remains set at $500 on that case. Court finds probable cause for fleeing or attempting to elude a law enforcement officer. Bond is set in that case at $1,000. And does the state have any input on the out-of-bond case, which was another driving on a suspended license where?
No action, just to remind the defendant that he is to not drive without a valid license.
All right, sir. The court does take no action as to the prior charge.
Thank you.
You are reminded
Yes, ma'am.
not to drive without a valid driver's license. That's a condition
Yes, ma'am.
of your release, okay?
Yes,
Thank
ma'am.
you.
Thank you.
Larry Lorenzo Jones.
Yes, ma'am.
All right, sir. The court does find probable cause for sale or delivery of cannabis. The court does set bond, reduce bond from $7,500 in your case to $2,500. Oh, actually, wait a minute. Nope, bond remains set at $7,500 in your case. Sorry. I apologize. it remains set at $7,500 in your case, sir.
For both of them?
Yes.
Or just for one?
Yes. The second case, the bond also remains set at $7,500.
Okay.
So the public defender is appointed on both your cases, sir. Thank you.
Thank you.
I forgot that this one was already right here. Cheryl Jones. You're not Cheryl Jones, okay?
Sure. We don't have a Cheryl Jones on the docket. What's the, inmate number?
Inmate number 200-11977.
Bonded, Your Honor.
All right, thank you. Tristan Kinlock.
Yes, ma'am.
The court does find probable cause for possession of cocaine within 1,000 feet of a convenience store or business. The bond remains set at $5,000 in that.
Objection to PTR.
Oh, PTR.
Yes, Your Honor.
All right, the court will order PTR as to count one. As to count two, the court will order PTR count three. The court will order PTR count four. The court will order PTR and count five. The court will order PTR. The court does find probable cause on all counts. Further, sir, the court is appointing the public defender to represent you. Thank you.
Thank you, ma'am.
Your Honor, the next person.
Case.
Okay.
Your Honor, is there any conditions to his case?
State, were you requesting any conditions? No.
Okay, thank you.
Tyquarius Javante Levy.
Refuse, Honor.
Mr. Levy will be rescheduled. He
Honor, we
refused.
waive his appearance.
Say there's no objection to ROR.
As to Tyquarius?
Yes.
Yes, Your Honor.
Okay. So as to Tyquarius, his public defender has waived his presence. The court will order ROR as to count one, possession of cocaine, and count two, possession of paraphernalia. Both, for both of these counts, the court did find probable cause. As to the no valid driver's license, the court will order ROR. And as to the prior charge,
Possession of cannabis as well, Your Honor.
yes, ma'am. Possession of cannabis, resisting an officer, possession of cannabis, conspiracy to sell or deliver.
No action, Your Honor.
And the court will take no action. So, Anthony Manso.
Yes, ma'am. Yes, Your
All
Honor.
right, the court does find probable cause on your case for first-degree murder with the firearm. Bond will remain set at no bond. I have appointed the public defender to represent you in your charge, sir.
Yes, Your Honor.
The court further orders no contact with the victim's family. Okay? Did I get that?
Yes, Your Honor.
Okay. Thank you, sir.
May I ask you something, though, Your Honor?
Well, the public defender is sitting right there, and I'm sure that, especially with the nature of your charge, they would prefer that you ask them. Unless, Ms. Fowler, do you want him to say anything to me? Ms. Fowler is the public defender who's representing you in court today, sir, and she has just confirmed that you shouldn't say anything without talking to the public defender first.
Yes, yes, Your Honor. Thank you.
All right. Thank you. Brandon Martin.
Can we pass by Mr. Martin for a moment, Your Honor?
Yes, sir. Freddie Mendenhall.
Yes, ma'am.
Mr. Mendenhall, the court does find probable cause for count one, dealing in stolen property. State, are you recommending a $5,000 bond on that or a reduction?
Reduction, Your Honor.
The court will reduce that bond to $1,000. As to count two, bond is set at loitering and prowling, bond is set at $100. As to count three, burglary of a conveyance, bond is $100. And as to count four, also burglary of a conveyance, bond is $100.
That's for no contact and no return, Your Honor.
All right, sir, no contact with the victim is ordered, victims is ordered in your case, as well as no return to the location where this incident occurred at. The court will take no action as to the other pending files that you, well, actually, the court, What says the state with regard to his? Court will take no action.
Okay. So I can block out?
Ivan Arias, okay,
He refused court, Your Honor.
okay, and is,
Your Honor, we waive his appearance.
okay, and is this Brandon Martin?
No, ma'am.
No, okay, so well, let's take care of Ivan Arias. The public defender was appointed and has waived his appearance.
What are you doing?
The court does find probable cause for both count 1 and count 2. Bond is stayed at 1,000 on count 1 and 100 on count 2. Court takes no action as to his prior case.
I'm not talking to you.
Michael Montgomery. Mr. Montgomery, the court does find probable cause in your case of possession of MDMA ecstasy. In your case, bond remains set at $1,000. Court does appoint the public defender to represent you, sir. Thank you, sir. Jaime Daniels Nieves.
He had Mr. Martin here, Your Honor.
Oh, okay, Mr. Martin.
Yes, ma'am.
All right, Brandon Eugene Martin.
Yes, ma'am.
Mr. Martin, the court finds probable cause for grand theft of a controlled substance. Bond remains set in your case at $5,000.
I have a question. Is that really controlled substance, or is that like a actual typo? Because I believe it has nothing to do with a controlled substance.
Sir, it's probably a typo if you believe that.
Yes,
But the bond does remain set at $5,000. What I need you to do is not talk about your case, though, and I have appointed the public defender to represent you.
Okay. Any other court date?
One moment, Mr. Brandon. Sir, the court is further ordering that you not return to the location where this incident occurred and have no contact with the victim. Thank you.
All right.
Jaime Daniels Nieves.
Your Honor.
Jaime Nieves. Yes.
Mental health. Mental
All right.
health.
Your Honor, we waive his appearance.
All right. The public defender was previously appointed and is now waiving his appearance. The court does find probable cause for count 1, possession of fentanyl, $1,000 bond stays set. Count 2, possession of heroin, $150 bond remains in effect, and count 3, resisting, $100 bond remains in effect. Nydia Lexi Oppenheimer.
Yes.
The court does find probable cause for count 1, possession of heroin. Bond remains set at $1,000. And count 2, possession of cocaine. The court sets bond at $100. The court will take no action, ma'am, as to your prior cases. And the court does appoint the public defender to represent you. Thank you, ma'am.
I'll go ahead and the bond.
You have bonds. The court actually reduced one of your bonds to $100. The other one does remain stayed at $1,000.
So I have a bond I could buy myself.
Well, you have a $1,000 bond on count 1 and a $100 bond on count 2.
So I could buy myself out.
If you are able, you can bond yourself out, ma'am. Is Jackson Jr. Principal?
Yes, Your Honor.
Sir, the court does find probable cause for possession of MDMA ecstasy. Bond remains stayed at $1,000. In your case, the public defender is appointed to represent you.
All right. Can I ask you something though?
Is it possible for me to qualify for pretrial release?
The assessment for pretrial release was previously done in your case, and I was advised that you do not qualify. Does pretrial release have any update on Mr. Principal, or does he still not qualify?
No, Your Honor, we don't have a further update. It just stated that he doesn't qualify. He has an open case out of Lee County
So
for,
unfortunate.
Yeah.
Oh, I'm sorry.
you can go ahead.
Unfortunately, sir, you still don't qualify, so I'm going to have bond remain at $1,000 in your case. Thank you.
Your Honor, would the court consider a court-ordered PTR? I don't see any Florida convictions on his in his criminal history.
No, the court will not consider any court-ordered PTR at this time. He has an open case in Lee County, and even though I interrupted the PTR official, that case is robbery with a deadly weapon, grand theft, over 750, and so because of that, the court is going to follow the recommendation of PTR staff, and he doesn't qualify. Barry Quentin Pryor.
Yes, Your Honor.
Has no objection to a bond reduction to $25,000 as to count 1.
Thank you, State. The court does find probable cause for counts 1 through 5 in your case, sir. As to count 1, bond is reduced to $25,000. Count 2, possession of cocaine, bond stays at $150. Count 3, possession of heroin, bond stays at $150. Count 4, possession of cannabis, bond stays at $100. And count 5, possession of paraphernalia, bond stays at $100. The court is appointing the public defender to represent you, sir. Count 1, if I didn't mention it, is possession, trafficking in greater than 10 grams, less than 200 grams of MDMA ecstasy. Thank you. Christian Ramos.
Yes, Your Honor.
Mr. Ramos, the court finds probable cause for the offense of robbery, armed robbery with a deadly weapon. Bond remains set at $5,000. Further, the court will order that you possess no firearms or weapons as a condition of release, and that you surrender any firearms or weapons to law enforcement within 24 hours of your release. The court is appointing the public defender to represent you on this charge. Thank you, sir.
Thank you.
Derek Robertson.
Yes, ma'am.
Sir, the court does find probable cause of possession of MDMA ecstasy, count 1. Bond remains set at $15,000. Possession of cocaine, count 2. Bond remains set at $150. Your second case, conspiracy to sell or deliver cocaine, bond remains set at $1,000.
Excuse me, Your Honor. I'm not meaning to cut you off. Is there any possible chance the count 1 there, ma'am? The 15,000 is so steep, ma'am. I don't know if we can't afford the 15.
Any objection from the state to reduction in count 1? All right, sir. As to count 1, the court will reduce from $15,000 to $7,500.
Thank you.
That's about half. The court does take no action on your other pending cases.
Thank you.
And if I did not mention it already, I have appointed the public defender to represent you. Thank you, sir.
Thank you, ma'am.
Harry Serkis.
Yes, ma'am.
Sir, the court does find probable cause for driving while your license was suspended as a habitual traffic offender. In your case, the court will reduce the bond that's set at $2,500. The court will set bond at $1,500. The court.
Ma'am, it was extenuating circumstances that my roommate was very
Your
sick.
Honor, I'll advise not to talk about the facts of the case.
All right, sir. Don't talk about the facts of the case. The voice that you heard is the public defender. She's present. The public defender has been appointed. The public defender is concerned that you may say something you shouldn't say about your case. Sir, even though I reduced the bond to $1,500, I'm revoking the bond.
Please don't revoke my bond, man. I'm working really hard to take care of those cases. I just hired a lawyer, and I was doing the right thing that day. Someone needed their medication. They were very sick. That's the only reason why I drove. Please don't revoke my bond, man. I've been working very hard to take care of those problems with those cases, and I'm doing the right thing, I promise.
Oh, I don't know if I can believe that or not, but I'll tell you what, sir, I won't revoke the bond.
Thank you, ma'am.
All right, no action on the other case.
Thank you.
Tammy Lee Lucas?
No. Tammy Lucas.
She's mental health, Your Honor. All right, thank you. Ms. Lucas bonded.
No, Your Honor, she's mental health.
Your Honor.
All right. Oh, sorry, but you all are kind of muffled when you. So
I apologize, Your Honor. Mental health.
Mental health. Okay.
Your Honor, we waive her appearance.
All right. Public defender was appointed and waives Ms. Lucas's appearance. Court orders that the court does find probable cause and bond remains set at $500. Amaris Caridad Rivera Mercado.
Yes, Your Honor.
All right.
There's no objection to ROR, Your Honor.
All right. The court will order, the court does find probable cause and will order ROR as to possession of paraphernalia and ROR as to driving on a suspended license.
Okay, so that means I get to leave?
Well, you are ROR, you're released on your own recognizance. You will get a court date and you need to make sure you keep in touch with your public defender.
Okay, thank you, Your Honor. God bless.
Thank you. Elita Williams. Elita Williams.
I don't have a, she's not on the docket. Could I get a jail number, Your Honor?
Inmate number 200-11968.
Thank you.
Christopher Clements.
Yes, ma'am.
All right, Mr. Clements, the court does find probable cause for your charge of trespass on property after warning. In your case,
The offer is adjudication of guilt, credit for time served, no return.
the offer is adjudication of guilt, credit for the time you've already served in jail, and no return to the property where this happened. He has another case as well of trespass. It may be the same location because I think I read and hear that he has multiple trespasses from this property. 2020 MM 371, I'm sorry, 3590.
Your Honor, we can't resolve that. We've not filed that information on that case.
All right. Okay, sir, as to the case that you are here on today, the one case, the state has made a recommendation to adjudicate you guilty, order credit for time served, and order that you not return to the location where this happened. I would also order court costs in this case and order you to pay that through the clerk's collections program. Sir, would you like to resolve the case at this time, or would you like to take the time out to talk to your public defender first before you make a decision?
I like to take time out to talk to my public defender before I make a decision.
All right.
Your Honor, will the court consider ROR?
No, bond will remain set. Well, actually, I would consider ROR in this case. Any objection from the state? All right, the court will ROR you as to this charge, sir.
Thank you.
No action as to the other case.
Your Honor, the Williams, she bonded.
Okay.
That was the case we just pulled aside for a second.
Well,
I got it.
oh, I gave it to the clerk. Yes, ma'am, thank you.
You're welcome.
Got it. Caitlin Hancock.
Yes, ma'am.
All right, Ms. Hancock, the court does find probable cause for your charge of possession of paraphernalia. Bond does remain set at $500. In that case, court takes no action as to your other charge. Thank you, ma'am.
Your Honor.
Is it a VLP? Oh, sorry. And the court also you need to remain, ma'am. Bond remains set at no bond as to your violation of probation charge. Thank you, ma'am. And I have appointed the public defender to represent you. Jermaine Michael Mann. Mr. Mann, the court finds probable cause for the offense of obstruction of the execution of a search warrant. In your case, bond remains set at $500. The court takes no action as to the previously charged case. Thank you. The public defender is appointed to represent you. Thank you. Bertice Taylor.
That's not me.
Mental health, Your Honor.
Your Honor, we wait for appearance.
All right, the public defender was appointed and waives the presence of Bertice Taylor. As to criminal mischief, the court finds probable cause. Bond remains stayed at $500. As to count 2, bond is trespass on property after warning. Bond is set at $150. No action as to the previously filed offenses. Raymond Wood.
Bonded, Your Honor.
All right, Mr. Wood, previously bonded. Stephen DeLeon.
Yes, ma'am.
All right, you were picked up on an out-of-county warrant from Hillsborough County. Count 1 bond is stayed at $2,000, and count 2 bond is stayed at $500. In your cases, sir, our staff will notify Hillsborough County and let them know that you are being held, and they will take action on your case as quickly as they can. Thank you.
Thank you.
Stanley Desir.
Yes, ma'am.
Sir, you were picked up on a probation violation from Lake County. Bond remains set at no bond. In your case, our staff will notify Lake County of your pickup, and they will take action on it as quickly as they can.
All right.
Thank you. And the public defender is appointed on your case, sir. Got to say it to the other guy. Ronald Gamble.
Yes, ma'am.
All right, so you were picked up on an out-of-county warrant from Palm Beach. Bond remains set at no bond. I am appointing a public defender in your case, and our staff will contact Palm Beach County, and they will take action on your case as quickly as they can. Thank you. Deshaun James.
Yes, ma'am.
Mr. James, you have multiple out-of-counties from different counties, including Seminole, Lake, Volusia County. Each of these counties will be notified of your pickup, and action will be taken on your cases as quickly as they can. The public defender is appointed on your cases.
On all 3 of them?
Well, I think there are more than 3.
All right.
Sir, at this point in time, we have a total of 6 cases, and the public defender is appointed on every single one of them.
All right. Do you know how long they have to come get me?
Well, we will notify them immediately, but there are multiple counties. You actually are released on your own recognizance as to 2 of the cases from Seminole County, but you have bonds on the other cases, $3,000 on a 3rd Seminole County case. Then you have a $3,000 bond on the 4th Seminole County case, $323 on the Volusia County case, and $5,000 on the other Volusia County case. So The bond, I'm sorry, you have one more, $1,000 on the Lake County case.
Thank you, ma'am.
Okay. All right. Yeah. Okay. I think he gets the picture. Christopher Margrave.
Yes, ma'am.
All right, sir, you were picked up on an out-of-county warrant from Volusia County. Bond remains set at no bond. The public defender is appointed, and the staff here will contact Volusia County to let them know that you were picked up on this case, and they'll take action on your case as soon as they can. You do have an Orange County pending case. No action will be taken as to that case.
Okay. Well, I'll
Thank
be
you, sir.
released ROR though.
No, there's a no bond
Oh,
on the out-of-county, no bond.
okay.
Hello, good morning, Your Honor.
Rafael Serrano.
Yes, good morning, Your Honor.
Good morning. Mr. Serrano, you were picked up on an out-of-county warrant from Osceola County for 2 counts.
Correct.
As to both count 1 and count 2, bond remains set at no bond. Osceola will be notified of your pickup, and they will take action on this case as quickly as they can. I am appointing the public defender to represent you. Thank you. Lloyd Michael Anderson.
Mental health, Your Honor, mental health.
All right.
Your Honor, we waive his appearance.
The public defender is appointed and waives the appearance of Mr. Lloyd Michael Anderson. The court does find probable cause for contempt of court, violation of no contact order. Bond remains set at no bond in that case, and stalking bond remains set at $10,000. Further, the court is ordering no contact with the victim in this case, possession of no firearms or weapons, and surrender any firearms or weapons to law enforcement within 24 hours of release. The court is revoking the bond or revoking the ROR in the previously filed case 2020 MM 154, and bond is set at no bond. Raheem Ellis.
Yes, ma'am.
Mr. Ellis, the court, you were picked up on a violation of probation warrant. Bond remains set at no bond on your case. I am appointing the public defender to represent you. Thank you, sir.
Okay.
Nikita Latrice Fairconiture.
Yes.
You were picked up on a violation of probation warrant. Bond remains set at no bond on that warrant. The court does appoint the public defender to represent you in this charge. Thank you.
Your Honor, she also has a contempt of court charge.
I'm looking through the paperwork and I don't see a contempt of court charge. Is that a different case number that you can provide?
Yes, it's a 2019 DR 1606.
No, ma'am, I don't have that information in front of me, but we'll retrieve it. And oh, we don't have it. We just don't have it. The clerk says you'll have to send it to her.
Okay.
Ms. Fairconiture, we're gonna put you at the back of the line. They're not gonna send you back because you have another case for me to call. And I do appoint the public defender on that case if I didn't say it. Jeremiah Johnson Waldron.
Yes, ma'am.
Mr. Jeremiah Johnson Waldron. Sir, you were picked up on a violation of probation warrant. Bond remains set at no bond on that case. The court does find probable cause for the new case, grand theft of a motor vehicle. Bond remains set at let me just ask the state. He has a count 1 and a count 2. Count 2.
Count two, we have no objection to 150.
Okay, all right. So as to count 1, bond remains set at $1,000, and as to count 2, the court sets bond at $150. Court does appoint the public defender to represent you. As to your other case, driving while your license, count 1, grand theft, bond remains set at $1,000. Driving while your license suspended or revoked, count 2. Any objection to $150? Bond is set at $150. And I think that's all of your cases, sir. The public defender is appointed on all of your cases. I think I got it. Wait a minute. No, that's all of them. Letha Gay Wells.
Yes.
The court, you were picked up on a violation of probation warrant, ma'am. Bond remains set at no bond as to the VOP. The court does find probable cause in your new law violation for count 1, possession of cocaine. Bond remains set at $1,000, and count 2, possession of paraphernalia. Bond is set at $150. The public defender is appointed to represent you in all cases, ma'am. Thank you.
The next person, Paul Clark, Your Honor, mental health.
Paul Clark. Paul Clark, charge of disorderly conduct. He's a mental health case.
Yes, Your Honor.
Your Honor, we will just reset the case.
All right, we'll reset Mr. Clark.
Yeah.
So, how do I know who is who?
Okay, so it's the second case.
John Weber.
Yes, ma'am.
All right, Mr. Weber is here on a status hearing. Contact was made with Judge Nymeth. The court, in accordance with Judge Nymeth, would set the bond at $2,000 with the following conditions: pretrial release conditions of that you possess and consume no alcohol as a condition of release, and that you are monitored by SCRAM, SCRAM monitoring for alcohol. Thank you, sir.
Thank you.
Marcus Wright.
One moment, Your Honor.
Okay, he's not there anyway.
You said right, Your Honor?
Marcus Wright.
It should be granted the state filed notice of non-filing before the 33rd day.
All right, the court will grant the motion. The defendant will be released as to this case only. Crawford Wright.
It should be granted the state filed notice of non-filing before the 33rd day.
All right, the court will grant the motion. The defendant is released as to this case only. Julie Felber. Julie Felber.
Sorry, they're not in order on my sheet, Your Honor.
Okay.
That should be granted the state filed notice of non-filing before the 33rd day.
Court will grant the motion. Defendant is released as to this case only. Michael Hooks.
That should be granted the state filed notice of non-filing before the 33rd day.
The court will grant this motion. The defendant is released as to this
I'm
case.
sorry, Mr. Hooks, what case was that, Your Honor?
This is 2020 CF 4284.
That's correct, Your Honor.
He also has a second case, 2020 CF 4906.
Yes, Your Honor, that should be granted the state filed no information on the 4906 case.
All right, the court will grant the motion. Defendant is released as to this case only.
What would they like us to do? So they said tomorrow.
What's her name again?
This case right here.
All right. As to Ms. Farrakanacher, does corrections have the additional information that we were awaiting?
We'll just reset it for tomorrow.
All right, this case is reset for tomorrow then. Or not this case, the other case is reset for tomorrow. Thank you, Ms. Farrakanacher. We're gonna bring you back in the morning. Anything else? Any other matters that need to be called on the record?
No, Your Honor.
All right, court is in recess. Thank you, corrections people.
Have a good weekend, Your Honor.
What
And
about
all
the rest of the court people?
And all, and all the court staff.
No, we're gonna have to say court people. We like
court people.
We like it. We like court people.
Okay.
We're gonna stick with that, at least for today. We're gonna call us court people and corrections people.
Yes, ma'am.
We'll go back to being corrections staff and court staff tomorrow.
Okay, well, I'll be at home then, so.
All right. Thank you. Court's in recess.
Okay, be safe.
She be speaking when she talks so fast. When she be talking so fast. Golly.